Good morning, everyone. Thank you so much for joining us in this new edition of the Absolute Immigration webinar series. We are also focusing this time, just the same way as we did last time, on the hospitality industry, an industry that is very, very interesting, busy, and certainly a massive user of the immigration program. Today, differently from last time, we are going to talk about compliance, which is very, very important. Compliance is an important part of the immigration program, so it is good to be familiar with all the regulations and the laws around this particular piece. Now, before we start, by way of introduction, I am Majlinda Lulo. I am the Immigration Director here at Absolute Immigration. I'm joined today by Jannaha Schillaci, who is our Immigration Manager in charge of our hospitality, visas, and immigration delivery. We welcome to the country. Our head office is situated in the lands of Wurundjeri people of the Kulin Nation, and we wish to acknowledge the traditional owners of the land. We pay our respects to elders past and present. A quick reminder that the information we provide today on this webinar is for general purposes only. If you require personal immigration advice, please do not hesitate to contact us, our immigration agents and lawyers. I'm more than happy to give you assistance tailored to your personal circumstances. If you have any questions, you certainly can put them in the chat box. We will address them at the end of the webinar today. You will also receive a copy of the slides and the recording, so you can watch that at your leisure. Now, again, if you require specific advice, please do not hesitate to reach out to us. We will be covering a few areas, and they are quite interesting, sometimes a little bit dry, but certainly important. We will talk about employer obligations, work rights, and sponsorship obligations, especially related to employer-sponsored visas, the 482 visa, the one that is commonly used by most hospitality workers and sponsors, as well as the 407 program. We will also talk a little bit about sanctions for non-compliance. This is also very important. So let's talk a little bit about some key practices. Obviously, one of the requirements is to pay in line with the market rates. What does that mean? What that means is that when you sponsor a foreign worker, the regulations, immigration law, requires you to pay that worker in line with market rates. So in line with the salaries that are paid for that occupation in the Australian market. Whatever you would pay to an Australian worker, you are expected to pay a foreign worker. You certainly need to hire for positions skilled in the occupation list. So obviously there is a list associated with the 482 program as well as with the 407 program. So you need to make sure that whoever you hire is on that list. Generally speaking, for the hospitality industry, that includes cooks, chefs, restaurant managers. Anybody else, Janelle? That's roughly it, isn't it?
Roughly it,
roughly yes. It. Yes. Another requirement is to obviously maintain records. So anything that has to do with employment conditions, contracts, position description, pay slips, this also has to be retained and kept safely in your records. And certainly you need to ensure that you cooperate with inspectors when they come to visit. As of 1st of July 2024, the Immigration Amendment Regulations 2024, the infringement notices, has introduced significant changes to ensure that there are stricter employer compliance with immigration laws. The Immigration Minister at the time, Claire O'Neill, last year introduced some very strict reforms that are aimed at addressing any non-compliance issues within the employer-sponsored space, but also wider sanctions for any employer that basically employs foreign workers. So since 19th of August 2007, so very, very early on in the piece, the Migration Act introduced criminal offences if you are to knowingly or recklessly allow an illegal worker to work in your business. So it's important, and this is why we stress the importance of checking the visa rights for any workers that you employ. And not only do you have to check the work rights, but you also need to check their visa conditions. So one, do they have work rights? If they are obviously on a tourist visa, for example, they can't have they can't work for your business. They can't do anything that has to do with your business. But also, if they have a visa, that visa sometimes does have certain conditions that allow them to work, but in a restricted way. A perfect example here would be, for example, student visas. And certainly there are other penalties and infringement notices that were introduced at the time. What does that mean? That means that you are required to take reasonable steps at reasonable times to conduct work checks. So you do a Vivo check, and we'll talk about that a little bit later. And you also need to do that regularly. You also need to make sure that you look at documents and confirm the work rights through Vivo or the visa grant notices. So you make sure that you do those checks very early on when you're onboarding your worker, even before you offer them an employment, actually, and during their employment, because visas change all the time. People apply for different visas all the time, and sometimes before you even know, they might not have the right to work. These are some of the sanctions that the Department of Immigration has introduced. As you can see, they're quite serious. Taking the, for example, fines for corporates. If there is a breach, that fine can go up to $412,000, and it can be deemed as aggravated offence. So they can come with sanctions of 5 years of imprisonment, which is quite serious for the company directors. So immigration is serious. Compliance is very, very serious. These slides, and I'll let you read these in your own time, but basically outline some of the legislative framework around the sanctions that the Department of Immigration has introduced towards employment of people without appropriate work rights. And the same in terms of breaching privacy laws, not being able to obtain permission to conduct work right checks, conducting those checks, and also failure to satisfy sponsorship obligations. And we'll talk about that. Jannaha will cover that in the second half of the webinar, because that is very, very important. So what do you need to do? Every employee is required to provide you with evidence of their work rights. Now, if they're a citizen, of course, they have work rights. Absolutely, they can work, they can do whatever they like. Same with permanent residency visa holders. They also can work in any occupation for you for any length of time, for any hours you wish to employ them for. That is not a problem. Of course, provided that you're compliant with Fair Work Australia, which is a completely different area of law. Now, if they are a temporary resident, though, that is a little bit different, because they will hold a visa, and that visa comes with work conditions. So what you need to do is you need to check their work rights as soon as you before you employ them. You can do that through Vivo. I'm not sure whether anyone has heard of Vivo, but Vivo is a facility that the Department of Immigration provides on their website. Any organization can register for Vivo and obtain login details and a password. And then what you can do is you can enter the details of the passport for your foreign worker and check their work rights. It is very, very easy to use. It's user-friendly. We use it as agents. We use it all the time. In fact, we don't start an application without checking a Vivo first.
Of course, obtaining the permission.
Absolutely, we do that. Yes. So it is important for you to obtain that position from that permission from your worker first, and then conducting that Vivo check just to make sure. A lot of our sponsors incorporate the permissions as part of their onboarding processes or recruitment processes. So that is automatic. And some of them also incorporate that in the employment contract. So basically, by signing an employment contract with you, the worker is also automatically authorizing you to do Vivo checks on an ongoing manner. Obviously, we are not employment lawyers, so please make sure you check all of these things with your employment lawyers. Now, please conduct ongoing checks for your temporary and permanent residents at least quarterly. The reason why we've put permanent residents in there is because sometimes permanent visas can also be cancelled. Usually they can be cancelled when the visa holder has provided misleading information to the department, or if they've committed a crime. So it is important that even though they are permanent residents, their visas are checked. With a citizen, obviously you don't have that requirement. You need to keep on file a written permission from the visa applicant that they have given you permission to do the check, and you certainly need to do that as part of your payroll. In case they don't wish to provide passport details, then we would suggest that perhaps they do a Vivo check in your presence, and then you keep a record of that. So that is also a good way to basically make sure that you are compliant with the requirements. So as we said, absolutely keep a Vivo check, but and also make sure they keep that in their file. So in case the Department of Immigration comes in and checks, and it's not actually a Department of Immigration, it's their branch, the enforcing branch called the Australian Border Force. They are the ones that will come and visit together with Fair Work Australia, and they will check your records. You need to also make sure that if you have a sponsored worker, they are performing the tasks and duties of their position. So if they, for example, were sponsored as a cook, then they need to be working as a cook. They cannot be working as a chef. They were not sponsored under that occupation. Yes, sometimes those occupations are very close to each other. The tasks sometimes overlap, but there is clear, tasks listed under each occupation, and you need to make sure that they are performing under those tasks. Any accompanying family members need to also be compliant with the specific conditions of the visa. Otherwise, their visas will be cancelled. If there has been a change on the visa status or the entitlement to work, the employee has the obligation to notify you as soon as that takes place. And again, you can make this part of their contract. This is because it is also on the visa applicant to make sure that they are compliant with any visa conditions. You, of course, can monitor, for example, if they are attending school or not. You can monitor how many hours they're working on you if they're on a student visa, but you can't obviously monitor anything else that is part of their visa conditions. But it is important to stress that it is their obligation to comply with those visa conditions. And this also applies not only to, for example, attendance for students, but also to private health insurance. The 482 visa, for example, has a requirement that any non-resident has to have private health insurance. Again, a massive compliance issue. While in circumstances where the application for a visa to work in Australia is still pending, you should really advise your candidates, your upcoming workers, if they are offshore, that they shouldn't sell property or make any changes, any significant changes to their lifestyle until they've got their visa. The amount of times that we come across candidates that are offshore and that they get obviously confirmation of an employment contract and they go and sell property is actually surprisingly large. So make sure we stress it from our side. So every time we talk to the visa applicants, we tell them, please do not make any changes until you get the visa. Otherwise, the visa may be refused for one reason or another, and all of a sudden they have been disadvantaged. So it's important to make sure that you advise them of that before they actually start the process. Here is a summary of the regulations applicable to any sponsorship obligations. So I will leave you read those separately, but it is, as you can see, there's quite a few of them, and we'll go through those in a bit more detail. Again, I want to stress compliance is very important. And this is why we're organizing this webinar, because we want all of our sponsors to be well informed of compliance and to make sure they're compliant all the time. Here are some of the obligations, and I'll let Jannaha start going through those. This is the first one, cooperating with inspectors.
Absolutely. So in terms of cooperating with inspectors, so sponsors are subject to auditing by the Department of Home Affairs, or actually the Enforcement Australian Border Force, together with Fair Work in some instances. They can arrive unannounced, they can request paperwork on site. It can be interviewing the receptionist up to the general manager in terms of, sponsored workers, what type of work they're performing, how often they come into the business. They can ask for documentation such as employment contracts, position descriptions, rosters, timesheets, and obviously what the department will be looking at there is to see if employees are being paid in accordance with the Australian market rates, but also are receiving their favourable conditions and of their employment contract. So they can come unannounced. Unfortunately, the downside to that is often there's no migration agent or migration lawyer to handhold that process. It can be quite, employers can be taken aback by that process. Sometimes, there is a request to provide these documents. They have to be readily producible within, usually it's about 10 days. Well, yes. It's a pretty short period of time that these documents need to be provided. This obligation starts when the sponsorship is approved and does continue for 5 years. At Absolute, we keep the records on file for 7, if not longer. In the event that there is an audit, we tend to have these documents available,
Ready.
you know, cessation notifications, change of position, and so forth. So a big obligation, which is quite important, and which is probably the focus of a lot of the immigration audits, is the equivalent terms and conditions of employment. So essentially the sponsored workers' terms and conditions must be no less favourable than the terms and conditions of an equivalent Australian worker. Now, this is initially assessed at the application stage, although for accredited sponsors, often this is just a given. It's accepted that, you know, the low risk sponsor would meet this requirement. However, it needs to be backed up at an audit stage. So ensuring that, you know, sponsors are paying the higher of the guaranteed earnings, which was approved by the Department of Home Affairs as part of the application process, or the annual market salary rate if it increases over time. So, you know, if an Australian employee is working as a sous chef, their salary goes up. A sponsored worker should also go up if they have equivalent skills and experience, just to ensure that they're keeping pace with the market rates. Employment conditions are also important. So other than the monetary earnings, they must be no less favourable. So the expectation of work hours. So you couldn't have a sous chef, for example, being paid $80,000 for 38 hours and a similarly skilled sous chef being paid the same amount, but with 40 hours. So the department would deem that to be not equivalent and therefore could potentially sanction the sponsor. The non-monetary benefits, I mean, look, if they are applied universally across the whole business, you know, Australian employees receive certain benefits, private, you know, health insurance from the business, it should be seen to be applied equally across the whole team, foreign workers alike. So individual contracts, which leave the sponsored worker worse off than they would be under a relevant award or agreement, would be a breach of the sponsorship or maybe a breach of the sponsorship obligation. One of the examples that we've seen recently, so, you know, sous chef often falls outside of the award, the Hotel Industry General Award, the Restaurant Industry Award. The department, you know, if they are seen to be earning less than a chef de partie would under that award, then that could be potentially problematic. So need to keep an eye on the hierarchy, and of course chefs should be paid according to that hierarchy. So just continuing on from that, so sponsored foreign staff must be classified and paid at the same level as an equivalent Australian citizen or permanent resident is, and that's obviously based on position, geographical location, qualifications and experience. Someone who's being paid a higher salary, maybe because of their skills and experience, you can defer to external market rates in that case. So whether it be job advertisements, Job Outlook, which is now Labour Market Insights, I believe, or salary surveys. So if the salary decreases, there is a requirement to lodge a new nomination and visa application. For example, someone might be not performing, they might need to step down from, say, sous chef to, you know, just as an example, to demi chef. That salary would need to be corrected through a new nomination and visa application. The exception being is, you know, perhaps people returning from maternity leave. When they return under the Fair Work provisions, they can actually come back part-time. That is permissible under the Immigration Act or regulations as well, providing their hourly rate of pay does not change. We would recommend notifying the department, though, of returned workers who are taking up part-time work, just so they're aware of it. If it comes to an audit, they're aware of the circumstances. However, just to flag, the part-time work may disrupt their pathway to permanent residency under the 186 TRT, Temporary Residence Transition Program, but that's for another day. So moving to the next slide. So our recommendations would be to conduct a biannual or annual review to ensure that the terms and conditions are no less favourable. So, you know, comparing, looking at internal salary bands and seeing where everyone sits in that band, ensuring that they are paid accordingly. When drafting the nomination application, only include the guaranteed earnings. You know, I have seen decisions where the approval letter includes superannuation, which obviously is not a guaranteed earning. So the earnings, the items that are not guaranteed are the bonuses, commissions, overtime, that's not guaranteed, and reimbursements. Ensure that non-monetary benefits are documented annually. This may include education fees, use of motor vehicle lease, servicing, residential accommodation, which is paid by the employer. So it's non-monetary. It's not money that's, provided to the employee to use as they will. It's provided on behalf of the employer. So superannuation contributions over the compulsory amount can be considered guaranteed earnings. So only over 11.5% currently. Health insurance policy and provision of laundering of work uniforms and meals can often be considered guaranteed non-monetary benefits. One thing to note is that after the nomination has been approved, the monetary earnings can replace non-monetary, but it can't be the other way around. So important to remember that. We have had an increase in the temporary skilled migration income threshold, which unfortunately has knocked a few hospitality workers out of applying for a subclass 482 visa. Cooks, for example, people starting out in their career in the hospitality industry. That has increased from 70,000 to 73,150, excluding superannuation. There are certain, strategies, I guess, that businesses are looking at. Often they're not declaring it previously; they're starting to declare it now. I mean, it's something that the workers have perhaps been always entitled to, but it just hasn't been something that is being discussed until now. So non-monetary benefits can make up the TESMIT if it's equally and reasonably applied to all Australians and sponsored workers throughout the bid. So universally applied across the business.
What would be one of those examples, Jannaha?
So you might have in the enterprise agreement, there might be non-monetary benefits that are actually built into that award or agreement. So that's probably the easiest way of determining if it's applied, throughout the whole business. I think that's probably an easy go-to. Perhaps private health insurance that's provided by the business. It might be a global one if it's an international business, but it's something that perhaps hasn't been referred to or considered before. There should be no concerns about the employee being able to support themselves. So they shouldn't be worse off with that packaging of monetary and non-monetary benefits. Guaranteed overtime can be calculated as well, although obviously this needs to be done in consultation with your employment lawyer, with immigration law in mind. So overtime that is guaranteed in the employment contract and assessed at the application stage can be permitted. The overtime must be mutually agreed to. Any penalties that apply to the overtime, so weekend work, overtime as per the award, that must be awarded to the employee. Other equivalent Australians must have the same terms and conditions, so same packaging, and the national employment standards must be met. So pay for return travel costs. This is enlivened when your sponsored worker still holds a subclass 482 sponsored by you. Once they enliven the obligation through a written request to pay for certain costs to return home, it must be paid within 30 days. You also need to notify the department that you have paid those costs, and that can be done through the cessation of employment notification. Those records also must be kept to personnel file, so written request of what has been paid. Usually it's just a basic economy flight, so usually travel from residence or workplace to the airport and then economy flight home. There's no requirement to pay any additional costs in relation to removal of personal effects or stopovers, hotel stays, etc. It's just simply back to usually the country of the passport.
How many people actually request this, Jannaha, in your experience?
Very little. So most people want to stay here. They want to become permanent residents. And so often when people leave, now that we have the condition 8607, which allows for 180 days to work unrestricted, people are using that time to actually find another employer, to get re-sponsored, to apply for permanent residency, to find other avenues. So very rarely.
Very, very little. Yes,
Yeah.
I think we've done thousands of visas, but I think I can count with one hand the amount of times that that has been requested. As far as I'm
Particularly for
aware.
the hospitality industry,
Yes.
a lot of workers are finding or trying to find ways to stay in Australia on a long-term basis. Okay, so when does the obligation end? So it ends when they're nominated by a new sponsor under the 482 program. If they're granted a new visa outside of the 482 program, for example, permanent residency, they've left Australia and their visa ceases. So if they have left, you know, often they might be leaving when their visa is coming up to expiry. Once it ceases, that's it. They can't enliven this requirement any longer. If they leave on a BVB and that BVB expires when they're offshore, it ceases as well. And I've just mentioned the condition 8607. It's an interesting one. We think that there might be, if there is an enlivening of this obligation, it's probably going to come 6 months down the track if an individual can't find a new sponsor.
They haven't, yes, they haven't
to support their 482. Yeah. Cost to locate and remove unlawful non-citizens. For me, this has never come up. It's a Commonwealth cost. If someone, you know, absconds, overstays their visa, you know, they have to be located, removed. You know, that cost needs to go somewhere. It's passed down to the employer, so it's a maximum of $10,000 minus any travel costs paid. But in my experience, I've never seen it being raised once. Next, so keeping records. So there are certain records that must be kept. Of course, during an immigration audit or request by the department, these must be produced quite readily. So the travel costs and details of payment, any change of event notifications, which is something we'll discuss further. So money paid to sponsored persons or money applied on their behalf, so non-monetary benefits. Task performs, that could be position descriptions, all charts, terms and conditions of equivalent Australian permanent residents, so market rates, keeping on top of those, and employment contracts, including any addendums for, you know, position changes, salary increases, so forth. So sponsors must maintain a comprehensive record to demonstrate compliance with the sponsorship obligations. Records include details of travel. We've covered all this, reported events, and must be kept for 2 years after sponsorship ends or the employee leaves. Providing records. So just this slide just maps out the type of records that are need to be provided to the Department of Home Affairs, Australian Border Force. A lot of the documentation is, you know, very similar to Fair Work in terms of employment. Documentation, documents in relation to previous slides we've mentioned, but also the administration of the business sponsorship approval. All those documents need to be housed together. Again, needs to be held for at least 2 years after the sponsorship ends. Notifying department when certain events occur. There is a 28-day calendar day grace period to notify the department of certain changes. If you are a company, then this is a list of you know, notifications that need to be made. So new director is appointed, administrator is appointed, business is wound up. So a lot of you know, mergers, acquisitions, business restructures, closing down of business. When this happens, it's always advisable to contact a migration agent or lawyer just to go through the process of what that means to any affected sponsored workers. Often when a business changes, ABN changes, then a new entity is created. Therefore, any affected sponsored employee needs to then be moved on to a more appropriate sponsoring employer.
A massive consideration if, for example, you are thinking of selling your business to someone else, you need to advise the new purchaser that there are sponsored workers as part of the business, so they'll have the option, just like they do with current employees. Of course, you'll have to advise them of how many employees they wish to retain and so on, but you have to provide some information in relation to your sponsored workers, because if they make the decision to retain them and not terminate them as part of the sale, then they'll have to sponsor them again, so take over their visas. So, and this can be a very sticky point in terms of negotiations for the sale of the business. So it's important to take that into account.
Absolutely.
Or if you're buying a business.
Yes. So notifying department, so what you should do. So obviously familiarize yourself with the obligations if you haven't done so already, and what are the reportable events. So change in business, even change in location or contact information, anything technically that's been declared in the sponsorship application form that changes needs to be notified to the department. You know, if a sponsored worker ceases employment, it needs to be notified, has changed in duties. We like to be across that before it's actually notified to the department, just so in case a new nomination and visa application is required. If the position is significantly changed, such as a new occupation, for example, going from cook to chef. Requested return travel costs, oh, they did not commence working with you. You know, if you do notify the department, someone doesn't start, they're offshore, it's important to do that so that you can perhaps look to have a refund of the Skilling Australia's fund levy. That can be done. As I mentioned, to have a chat to us or your migration agent lawyer in terms of these changes, because they might have an impact on the sponsored employee and your obligations as well. So moving on to the next. Oh, just
The technical issue.
just have that corrected.
There we go.
Oh, here we go. Yes, so that's just a couple of questions. So obviously reviewing the sponsored roles biannually, I think we've mentioned this before. There has a task change, has the guaranteed earnings changed? Obviously, we don't want them to be reduced because that might result in new nomination of visa application. Going up is perfectly fine and probably should be doing so if it's in line with market salary rates. Has a location change? Now, this is an interesting one. We often do have people that are moving from, say, Melbourne, a Melbourne venue to a Sydney venue. It's always important to take into consideration, does the move actually change the market salary rates? Does that need to be considered? Does that need to be adjusted slightly? So if you're going from a smaller venue to a larger venue, the larger venue pays their chefs higher, which they might do if there's more responsibility, more later hours, for example, then you need to adjust that person's salary accordingly. So the first thing the department always says is, do you have someone internally that's Australian, that's performing the same role, same location? What are they being paid? You know, the nominee salary should match unless there's a discrepancy in terms of skills and, you know, education qualification. Has the employer changed? So this is your restructuring. Obviously, if the employer has changed, then you know we need to set about regularising the sponsored workers' visa situation. Okay. So I'm just going. Okay, so not recovery of certain costs. So there's certain costs that the sponsor must pay for and can't pass down to the visa applicant. Those costs are in relation to the sponsorship and nomination application and includes both the government charges as well as the migration agent charges. There's also certain recruitment costs that can't be passed down to the sponsored employee, and then list, you can read through that at your leisure, but there are some examples there. There are certain costs that can be paid by the employee. Those costs are specifically in relation to the visa application and providing they don't form part of the recruitment process. So if the sponsored employee agreed to pay for those costs in order to entice someone to a role, perhaps it could be considered a recruitment cost. But look, if it's something that the employee is willing to, you know, they're wanting to engage their own migration agent, they're willing to pay those costs, then that will be fine. So any costs in relation to the government charges, migration agent fees for the visa application, English, health, character, and travel and accommodation in Australia is fine. So not engage in discriminatory recruitment practices. What this means is essentially that the recruitment process can't adversely affect Australian citizens or any other persons based on their visa status or citizenship status. And there's just a quick snip from the migration regulations in relation to what that means. So discriminatory recruitment practices include interviewing and hiring persons of a certain citizenship or visa status, or only advertising on mediums that predominantly accessible by persons of a certain citizenship. Non-discriminatory practices are your intra-corporate transfers, your internal recruitment and promotion, as well as renomination of sponsored workers. So sanctions for non-compliance, Mel you've mentioned a few of these already.
Very serious. Barring from sponsorship, refusal of sponsorship applications, cancellation of existing sponsorships. There is enforceable undertakings, and the idea there is to obviously prevent future occurrences. There's civil penalties, and then there's also criminal penalties. One thing to mention here, and I don't know, it might be in the next slide actually, is that if you happen to be sanctioned by the Department of Immigration, there is a public register of all the sponsors that are barred or sanctioned, temporarily suspended. But that is a public domain, so anyone can go in and have a look and see which sponsors have been sanctioned. So it is a serious measure that the department again has taken to deter a practice where a sponsor will be doing the wrong thing, so to speak. So it's part of their measures, and they take that very, very seriously.
And with the changes on 1 July, they've also spoke about barring sponsors from actually recruiting temporary workers
Of any kind.
Of
Yes,
any kind.
of
So
any
it could be
kind.
on a student visa 408, 403. So that is a huge change in terms of, you know, applying those
Yes.
sanctions. Yeah.
Any questions? A reminder that everyone will be receiving a copy of these slides. The legislation is quite extensive in this area of the law, but if you have any questions, absolutely do not hesitate to reach out to us. Well, thank you so much to everyone for attending. As I said earlier, in this webinar, if you have any questions or if you require specific advice, if you need help with sponsoring a visa foreign workers, or if you need help with your compliance program, please do not hesitate to reach out. We have a legal arm here at Absolute Immigration that specializes in compliance, and we can certainly come in, meet with you, look at your procedures and policies, things that you have in place, and then recommend some changes to make sure that you are compliant with immigration law. Thank you, Jannaha. It's been a pleasure, as always. Thank you, everyone.
Thank you.